Hi, this is video number 135 entitled Foreclosures After HAMP, and I am Carl Pearson, a New York attorney, devoting much of my time to defending foreclosures. Even though I'm a New York attorney, I am able to assist attorneys in other states with the preparation of litigation documents for use by them. I say this because the termination of the federal HAMP, or Home Affordable Mortgage Program, on December 30th, 2016 is being felt nationally and will be substantially increased in effect in all 50 states. And I wanted to give homeowner-mortgagors my insight into this newly created problem and how I plan to deal with the problem on behalf of my clients when appropriate, of course. When the nation's banks were close to failure in 2008, the federal government gave the banks huge sums of money through the HARP program. As Wikipedia states, the Troubled Asset Relief Program, that is HARP, is a program of the United States government to purchase toxic assets and equity from financial institutions to strengthen its financial sector. That was signed into law by U.S. President George W. Bush on October 3, 2008. It was a component of the government's measures in 2008 to address the subprime mortgage crisis. Wikipedia reports that close to $500 billion was provided in TARP, with all of it being recovered by the federal government, which, somehow I doubt, but that's what they say. A small part of TARP was the HAMP program, but as I said, HAMP has now come to an end just 2 months ago. This presents a major problem for homeowner-mortgagors because under HAMP, the federal government was paying the major bank lender or its loan servicer the amount it was losing when modifying a mortgage loan through interest reduction, principal reduction, forbearance, or other ways. Now, however, the lender and note owners in securitized loans, this means the thousands of persons who have invested their money in the pooled notes and mortgages, see their investment reduced in amount by the amount of benefit received by the mortgagor in a loan modification agreement. Now that HAMP has ended, any loan modification is going to be an, quote, in-house, unquote, modification for which there is no loan compensating program which compensates the lender or note owners for the benefits received by the mortgagor in an in-house loan modification. Investors, when asked to give their consent to a proposed reduction, that is, a proposed loan modification, would generally say, hell no! Why should I have to give up any part of the money I earned and then invested in this mortgage pool? That simply is the problem. Whether the homeowner-mortgagor is in one of the 28 non-judicial foreclosure states, or whether he or she is in one of the 22 judicial foreclosure states, the problem is the same. Now, here is my thinking on the problem. First of all, the homeowner has to understand that generally, in absence of a statute of limitations defense or a breach of contract defense in which the bank reneged on a loan modification it promised, the only practical way for the defaulting homeowner who's unable to make his mortgage payments to keep his mortgage property is to obtain a loan modification agreement. If a foreclosure proceeding is started and the homeowner does nothing except possibly apply for a loan modification agreement, I believe that the foreclosure will probably take place and the homeowner will lose his or her home. If the homeowner tries to act as his or her own lawyer and go into court to try to stop a sale, the lack of legal and mortgage foreclosure defense skills will probably slow things down a bit, but the foreclosure and sale will still take place. Something that you should know at this point is that with millions of foreclosures having taken place, There are almost no trials at all of the various issues that homeowners find in their internet searches and present to the courts. These issues are generally disregarded by judges when determining motions for foreclosure or motions to stop a foreclosure sale. Motions in the long run are almost always won by the bank or its servicer, which means that as a practical matter, the only way to stop a foreclosure and keep the property is to obtain an affordable loan modification agreement. Before HAMP ended, this was a likely possibility for millions of homeowners, but now that HAMP has ended, this way of saving the home has been closed down. If the homeowner hires an inexperienced attorney, such as a friend who usually does real estate transactions or possibly loan modifications or matrimonials or slip and fall or other negligence cases, the lender and its attorney will generally see from the quality of the litigation, that is a poor answer, a late or no answer, other missed deadlines, failure to seek discovery, and other telltale signs, that the attorney probably will not be much of a problem, so that the planned foreclosure can take place without any reasonable fear of being stopped by the inexperienced attorney. However, if the homeowner-mortgagor is represented by an experienced or highly experienced mortgage defense attorney, the lender and its attorney will see immediately from the complaint in non-judicial foreclosure states or the answer in the other, that is the judicial foreclosure states, that the attorney is going to be trouble for the bank and its attorneys, and this is more apt to encourage the bank to give an in-house loan modification to get rid of the attorney and associated problems than if the homeowner-mortgagor was represented in any of the other ways just discussed above. I can't scientifically prove the foregoing, but it makes sense to me, and it guides me in my defense efforts. The bank's situation is compelling up to a point, meaning that it offers a copy of the note and it records that the note has been in and the records which purport to show that the note has been in default and purported proof that it owns a note, which makes it difficult for a judge to decide against the bank. However, a good attorney can often, but certainly not always, find issues that raise doubt about the bank's claim of entitlement to foreclosure. And that may be the most critical thing I can tell you, that a good attorney will find or is in a position to find issues that will escape the attention of all the other ways that a homeowner can be represented. And it's only those rare issues that the skilled attorney may be able to find that may be able to save the home. So remember that when trying to decide how to proceed, that a better attorney, that is one who's skilled in this area, has a much better chance of finding the issue that may help you save the property, and there's no other way of doing it. Various laws were set up by the 50 state legislators, making it difficult for by the 50 state legislatures, making it difficult for a mortgagee, that is a bank or lender, to foreclose on a 1 to 4 unit residential building. An experienced foreclosure defense attorney can and should find and raise these issues and raise some doubt in the bank's mind about the litigation. Here are some of the thoughts that the bank and its attorneys may be having when a homeowner-mortgagor is represented by an experienced foreclosure defense attorney. 1. The inevitable litigation delays for many months or several years or longer, and I might add my longest case is now about 17 years of non-payment. Next to that is about a 10-year period. Now these are rare, but they do happen when you have, it's more apt to happen if you have an attorney, a good attorney, an experienced attorney I should say, which means that for that extra period the property will not be performing, that is, it will not be generating revenue for the note owner. 2, the attorney may come up with some legal issues which, if decided against the bank, could cause a precedent that others will use and wind up costing the bank many millions of dollars or more in many foreclosures. I just had an attorney call up for a bank saying that if what I said is true, that it could cause the bank to go under. And they asked if my client would be willing to take a loan modification agreement so we can get out of this litigation. That's a desire and that's a hope. It isn't going to happen all the time, but it's more apt to happen if you have a good, experienced foreclosure defense attorney. The attorney may come up with some legal issues, as I said, which could cost the bank a lot of money if decided in favor of the homeowner. 3, the legal costs for the bank could amount to $50,000 or $100,000 or more in some cases, depending on the course, depending of course on the amount of discovery, the number of motions, the number of appeals, and any hearings, or even a rare trial. The bank should consider offering a loan modification benefit comparable to the legal costs it would pay, because in most instances the bank would not be able to recover these costs from the homeowner or the mortgage property if sold at auction. 4, the experienced foreclosure defense attorney can be expected to create extra work for bank officials and upset their pattern and their work effort when responding to discovery requests, that is, requests for documents, answers to interrogatories, and the time and cost spent in preparing for one or more depositions and giving one or more depositions, taking a whole day and travel time and the like. A deposition, by the way, is oral testimony recorded before a reporter called a court reporter. It is through the deposition that the bank's asserted position can often be shown to have less merit than the bank is representing to the court, and may be vital in the non-judicial foreclosure states where the homeowner has to prove a negative, that is, that the bank doesn't own the note, to be able to get a stay. It is impossible to prove the homeowner's case, that is, prove a negative, without that deposition, and in some cases the deposition will wind up proving nothing of value, I should add. So you don't always win, but if you don't try, you are probably not going to win at all. 5, as success, and win, by the way, means keeping the property through a foreclosure with a loan modification agreement, not winning free and clear. 5, a successful defense could cause other homeowners to decide to do the same thing, so that it may be best for a bank to close down a lawsuit where this might occur by giving an in-house loan modification it really doesn't want to give in order to avoid these foregoing problems. 6, also, many mortgagees allocate their business among competing law firms according to the speed with which they are able to make the foreclosure auction sale. And if an attorney sees that there is a threat of substantial delay, it is possible, and I'm just guessing here, that the bank's attorney may assist in getting its client, that is a bank or servicer, to agree to a loan modification agreement so that that long delay is avoided. A continuing problem for most homeowner-mortgagors is their inability to find an experienced foreclosure defense attorney or one willing to take on the case. I have a solution for that problem, which is that the homeowner-mortgagor should have his or her initial pleading, that is a complaint or answer, prepared by an experienced foreclosure defense attorney wherever in the United States he or she may be located and found. And after the pleading is prepared, look for a local attorney in the county where the property is located to be the homeowner-mortgagor's attorney, and email that attorney the proposed pleading in PDF form and ask if the attorney would be willing to be retained for the case and use that pleading modified to the extent the attorney believes appropriate, because that attorney will be the one representing the homeowner. That local attorney should also be told that the attorney outside of state who prepared the pleading is available at any time for assistance or preparation of documents that may be needed in light of the pleading, and which attorney will be paid by the homeowner-mortgagor as part of his arrangement for the preparation of the pleading. This is what I believe is the best way to handle a threatened foreclosure now that HAMP has ended. And by the way, when I say HAMP, I'm really also referring to HARP, which has also ended. HARP was where people that were not in default were able to, but could not afford their mortgage, were able to get a mortgage reduction to enable them to keep the property even though they were not in default. But both of those have ended with the same consequence. A word of warning. Each of the 28 non-judicial foreclosure states has its own rule for giving notice by the bank or servicer about the mortgagee's intent to foreclose. And the number of days varies. The number of days notice varies from about 120 in California to about 13 in the state giving the least notice. The longer the notice, the more time the homeowner has to make use of a lawsuit to stop a threatened foreclosure. So if a homeowner plans to sue, he or she should sue as soon as the notice is given and not wait until the notice period is almost finished or substantially finished. You have a better chance to obtain evidence to stop a threatened foreclosure if you use the maximum period available to you. That is, in California, 120 days. In some states with a short notice requirement, there may not be much or any opportunity at all to use a lawsuit to try to stop a threatened foreclosure sale. I purposely have avoided discussion of bankruptcy filings for a variety of reasons. I don't like bankruptcy filings, but in some cases they are definitely needed. If you have any questions about what I have said, please email them to me at carlpers2@gmail.com. That's carlpers2@gmail.com, and I'll get back to you, or call me at 212-307-4444. This is the end of my video number 135. I look forward to helping you if I can.